Okay, well, it's again a pleasure to have Professor Marmo here for his third conference on authority, legitimacy, and accountability. So I won't take any minute from his talk. Welcome again, Professor Marmo.
Thank you. You shouldn't say again. Say still. Okay. Well, thanks for still having me. All right. So I don't know if this. I forgot to ask if the paper was made available to you. Great. So this is very much work in progress. It's not a finished paper. Still requires work. So comments and questions and suggestions are very welcome. I will probably not have time to give an account of all of it. But I'll do my best, and we'll see how it goes. It also just dawned on me last night that when I talk to American or British audience when I present this paper, I don't have to say much about Joseph Raz's theory of authority because it's so influential and so central to legal and political philosophy that pretty much everybody knows not just the outline of it, but the details of it. But then I realized that maybe that is, or quite not likely, not the case here, right? So, okay, so I'll say, here's what I try to do in this paper, okay? I try to say one main thing, that practical authorities in general, not just political authorities, any practical authorities cannot be legitimate authorities, morally legitimate authorities, unless they satisfy what I call a condition of accountability. Unless they are such that they can be held accountable for their decisions and actions. So I present accountability, I argue for accountability being a condition of the legitimacy of practical authorities. Okay? That's the point. Now, this point goes really directly against, or seems to be irreconcilable with, Joseph Raz's extremely influential theory of what makes practical authorities legitimate, which is called the service conception of authority. So let me start there, okay? What is the service conception of authority? So Raz starts his discussion of authority, practical authorities. Maybe I should start one step backwards. Raz, like many others, draws a distinction between practical authorities and epistemic authorities. Practical authorities give us reasons for action. Epistemic authorities give us reasons for belief. Okay? So we're bracketing epistemic authorities. We're not interested in epistemic authorities. When you say Professor so-and-so is an authority on tort law in Brazil. That's not the kind of authority we're talking about. Talking about practical authorities like political authorities, the authority of the dean or the president of the university, the authority of parents over their children, etc. Mostly, of course, we'll be talking about political authority. So one of the challenges to expanding the legitimacy of practical authorities, any authority, is the so-called anarchist challenge. And the anarchist challenge says this: look, a practical authority gives you reasons for action, tells you what to do. Why would it be rational, ever, to do something because somebody tells you to do it? And how would it not go against the ideal of personal autonomy? Right? The requirement that people act on reasons that they figure out as the correct one. Again, doing something just because somebody else tells you to do it. So Raz takes this challenge seriously, says, yes, we need to answer that. And his answer is that there are cases in which it is rational to do something because somebody else tells you to do it, if and only if it is likely to make you act on the right reasons for action that apply to you anyway. Yeah. So the idea is that the role of practical authorities is to mediate between the reasons that apply to the subjects, to whoever is the subject of that authority, and the subject. In other words, we should comply with practical authorities when complying with the relevant authority is such that it makes us more likely to act according to the reasons that apply to us anyway. The authority is not there to change reasons that would apply to us, just to make it more likely that we conform to those reasons. Yeah? Not necessarily because the authority knows better what needs to be done. Sometimes it's just there to solve a collective action problem or coordination problem. Doesn't matter. Okay? The idea is that authorities provide a service. They just make it more likely that we comply with the reasons. And that the main thesis of that idea is called the normal justification thesis. That's how Raz called it. So in case you run into it, you know what it is. I just want to read you the exact formulation of it. So the normal justification thesis says this, that if and only if, by complying with an authority's directives, subjects are more likely to act on the right reasons that apply to them than by trying to figure out or act on those reasons by themselves, then the authority is legitimate. Okay? So that's the basic idea. And of course, you know, there are many complications and you know, the full picture of Raz's theory of authority would take much longer to present. But the core idea is that the authorities are legitimate because and insofar as they provide a service. They just make it more likely that we comply with the reasons that apply to us anyway. Okay? All right. So that's the rationale of legitimacy of practical authorities. There's no room for accountability, no need for accountability. Accountability doesn't come into the picture. So I could argue that Raz is wrong and the service conception wrong and doesn't capture what makes authorities legitimate. But that's not exactly what I'm arguing. What I'm arguing is that Raz's conception is right, but not about legitimacy. So the main distinction I want to begin my argument with, and I think it's an important distinction regardless of accountability, is the distinction between legitimacy and what I call soundness or justification. Okay? I think that the normal justification thesis, Raz's service conception of authority, probably captures very well the idea of soundness. The answer to the question, why should I comply with any particular authority's requirements or demands or directives or whatever. Okay? In other words, what makes it justified or sound, reasonable? Yeah? Because if I comply, I'm more likely to do what I have to do anyway. But legitimacy is not that. Legitimacy and soundness come apart. I hope I don't get in trouble. Of course I will get in trouble. I always get in trouble. But I'll give you an example, just to bring the intuition home, very much home. Think about your former president. Yeah? It's funny now. It wasn't funny a year ago. Okay. I can also give my former president. Same deal. Yeah. So did they comply with the normal justification thesis? God, no. Yeah. It's crazy to think that they were legitimate presidents because they provided the service that we are more likely to comply with the right reasons that apply to us if we comply with their presidential decrees. That's just too funny to be taken seriously. Yeah. But doesn't mean that they were not legitimate presidents. Yeah. Why? Because legitimacy has something to do with answering the question, how did they get there? What made them have the authority they had? In this case, fairly reasonable, reasonably fair, democratic processes, democratic procedures. Yeah. Well, that's surely part of the answer. But in any case, I think we can see clearly that legitimacy and soundness come apart. Yeah. And of course, legitimacy does not guarantee soundness. Yeah. Just because your former president, like mine, was legitimate, had legitimate authority within the Brazilian legal system, doesn't mean that his directives complied with the normal justification thesis or that they were sound in any other sense. Yeah? So that's the intuition. So what's legitimacy? Yeah, if it's not soundness. So again, this stage, just intuitively, here's the idea. The idea is that every practical authority has a package of normative powers. Normative powers they exercise and normative powers they claim to have. Yeah? What are normative powers? They are normative ability to change somebody else's obligations or rights or duties or powers, etc. Okay. So every authority is a package of normative powers. As long as the package of normative powers that an authority exercises and or claims to have is, all things considered, not morally objectionable, their authority is legitimate. That's the idea. There is a reason for formulating it in kind of almost like a double negation or in a negative conditional, because I'm not claiming that an authority is legitimate only if there are good reasons for having it, all things considered. No, sometimes we have practical authorities not because there are very good reasons for having them, just because they're there, been there a long time, blah, blah, you know, contingencies of history. And that's fine, as long as there are no compelling reasons not to have it. Yeah? So that's the idea of legitimacy. Now, of course, we'll have to tell a much more complicated story. Yeah? But note that legitimacy just like soundness, actually, allows of degrees. It's not a yes or no, which is totally in line with our intuitions, right? It can be more or less legitimate. And sometimes there are borderline cases. Yeah, sometimes we have authorities where we can't say with enormous confidence that they are legitimate. We can't say with enormous confidence they are not legitimate. Yeah. I think that's true about many regimes in the world, though. Somewhere in between. Okay, so what I want to argue in this paper is that regardless of whatever it is that determines the soundness of political authorities, what makes political authorities such that people would have good reasons to comply with their directives, whatever the right theory about that is, and Raz's theory seems to me like a very plausible candidate for that, legitimacy is a separate issue, and that I want to argue that a condition for the legitimacy of authorities, not sufficient, necessary condition, morally necessary, is accountability. Okay, and now, of course, I'll explain what I mean by accountability and all of that. Okay. Now, so far, all you have to accept at this stage is this distinction between soundness and legitimacy, that soundness and legitimacy can come apart. Okay? Authority can be legitimate without being sound, like our previous presidents, for example. Authorities can be sound without being legitimate, but then we don't care much about their soundness. Although sometimes we do. So here's a kind of fairly minor point, but something that would create problems for Raz's account. Sometimes, in some contexts, subjects of a political authority would have moral reasons to comply with some of the authority's directives, even if the authority is by and large illegitimate. Why is that? Because even illegitimate authorities that are compelling reasons not to have, maybe compelling reasons to topple, to remove, yet they can issue directives, have laws that are morally important for us to comply with, regardless of the illegitimacy of their source. Right? What exactly those cases are is debatable, right? But even the most corrupt and illegitimate authorities have some laws that we have good moral reasons to want to have, like, contract laws, basic contract laws, if they are not grossly unjust, or basic criminal laws, again, if they are not grossly unjust, etc., etc. Okay? All right. So how do we get from the distinction, how do we get from legitimacy to this idea of the need for accountability? And here the essential step in the argument is the idea that's called these days legitimate errors or legitimate injustice. I did not invent this idea, right? Don't claim credit for it. I'm just endorsing it, almost without much argument. So the idea is that if you have a legitimate authority, then the authority has a right to exercise its directives, its powers, and others have no claim right to demand the authority not to do that, even if the authority is mistaken, in error on the merits. Yeah. So the idea is, if the authority has legitimate, if you have a legitimate authority, and the authority is issuing directives within the legitimate package of its normative powers, then even if the authority is wrong on the merits, unjust, people do not have a claim right to demand the authority not to exercise the power, and the authority is immune morally and legally from exercising it. In other words, legitimate authorities can make errors, can make mistakes, sometimes including injustice. Well, that's the idea of legitimate error. And I think it's correct. I think that it's very difficult to understand the idea of legitimacy and how practical authorities operate and their role in our lives without admitting that legitimate authorities can make mistakes. That doesn't mean, by the way, I do not mean to conclude from that or imply that one has a good moral reasons to comply with any legitimate authority's decree, even if there are reasons not to do that. Yeah. So not every idiocy of Trump is something that anyone has good reasons to comply with. Okay. Just means that we don't have a claim right to demand from Trump or whoever, assuming they were legitimate, right? I mean, some people might think that's a very generous assumption, but let's make that. We don't have a claim right to demand that they don't exercise their power. So what's the practical significance of that, of this idea of legitimate error? The practical significance is that the subjects of an authority need to bear the cost of the authority's errors. Whatever mistakes in terms of justice, morality, or any other, whatever mistakes practical authorities make, the cost of it is borne by the subjects. So that's where I think accountability comes into the picture. It's fair. It would be a fair deal between authority and subjects, only if the subjects have some kind of an insurance policy, as it were. I mean insurance here metaphorically, right? Not literally. Because we as subjects need to bear the cost of the authority's errors, we have a right to demand that the authority be accountable to us. So accountability is like an insurance policy, or like a balancing aspect. Yeah. So what do I mean by accountability? Not exactly what is called accountability these days in the philosophical literature in moral responsibility. The philosophical literature, at least in the US, UK, etc., in analytical philosophy, is very heavily influenced by Strawson's account of responsibility in Freedom and Resentment. And that generated an enormous amount of literature that also includes very interesting literature on the idea of accountability that I'm not going to go into. It's a sense of moral accountability. It's this, what moral philosophers are talking about when they talk about accountability is the sense in which we can hold you responsible, morally responsible for something. Yeah, that's the idea of accountability. So that's not exactly what I'm talking about. I'm talking about a much more practical sense of accountability, and it consists of two requirements. First, that authorities need to disclose their reasons for their decisions. The requirement of disclosure. Let's take an example, okay? Suppose I go to my dean and I request a sabbatical next year. Why? Because, according to the terms of my employment, etc., I'm entitled to a sabbatical next year. I wish, but it's an example. So I go to the dean and say, can I please have my sabbatical next year? And the dean says no. And I ask her, excuse me, but why? And she says, it's none of your business to know. Yeah, you don't need to know. Really? I think I have a right to know. Yeah, that's the sense of disclosure I'm talking about. Okay. Are there no exceptions? You think surely there are legitimate authorities or contexts in which legitimate authorities issue directives, make decisions, but they don't really have to disclose their reasons. I don't know. People argue with me about that. I think that the one main exception actually proves the rule, proves the point. The main exception that comes to mind is parental authority. Right? So parents of young children, not your parents, sometimes often make decisions, especially if the children are very young. They don't really have to disclose the true reasons because they are too complicated, because the child is not going to understand it anyway, or understand it the wrong way, etc., right? So we understand that we don't have to tell children exactly why we make the decisions we make about them. Up to a point, yeah? Up to an age, etc. That's true, but it kind of proves the point, because we surely, practical authorities cannot treat us as if we are children, not willing to disclose their reasons for their decisions is infantilizing us. So, no, you're not, smart enough to understand. That's not acceptable, right? But I'm willing to entertain the idea that disclosure has some limits and sometimes it's not fully required. That's not the point. The point is the following. I'm assuming, and I explained that assumption a little bit in the paper, that generally speaking, we do not have to disclose our reasons for action to anyone unless there are good reasons for doing that, for requiring that. So in many cases, somebody asks me, why are you doing this? It's perfectly okay for me to reply, it's none of your business. Yeah? That's my assumption. Not everybody agrees. Steve Darwell doesn't agree. All the worse for Steve Darwell, in my opinion, but that's a widely held assumption, certainly argued for and held by Raz and many others who write about moral responsibility and accountability. Sometimes it's okay to say to another, you don't need to know. It's none of your business to know why am I doing something, or what my reasons are for doing something or not doing it. So that's the background assumption. The requirement of disclosure is that this background assumption is not available to practical authorities vis-a-vis their subjects. Right? They cannot tell the subject, it's none of your business to know. You don't need to know what my reasons are for the authoritative decision. Okay? That's part one of accountability. Now, part one is not enough. Let's keep up the story with the dean. Go to the dean, ask for my sabbatical. She says no. And I ask why. And this time she doesn't tell me that I don't need to know. She said, okay, I'll tell you the reason. I had an epiphany last night. God appeared to me and told, when Andre comes to ask for a sabbatical, say no, he doesn't deserve it. Something crazy like that. So she complies with the requirement of disclosure. She truthfully discloses her reasons for denying my request. It's just that the reason is unacceptable. Yeah? Deans should not make decisions according to conversations they have with their gods. So accountability would be useless if it's only a requirement of disclosure, because then I find myself having absolutely nothing to do about it. And the sense is I should have some recourse to remedy, have some recourse to do something about it. So suppose I write a complaint to the, I don't know, university rector. Do you have rectors, provosts? What do you have here?
President.
President. Good enough. Okay, so I suppose I write a complaint to the president and saying, look, my dean is, acting crazy. And I wait for response and I never get it. And then I learn that all these complaints just automatically go to junk mail. Nobody reads them. So I try to complain about that. Again, nobody reads the complaint. They go to junk. So this Kafkaesque world would be a world in which there is no accountability, right? Because even if I know the reasons that the authority relied on in making their decisions, if there is absolutely nothing I can do about it, not even bring it to the attention of those who should know about it, then there is no accountability. So the second part, the second ingredient of accountability is some access, practical access to remedy, some practical access to do something about it. Okay? All right, so that's all very nice. Somebody might say, what's the mechanism in different contexts for making authorities accountable? How do we achieve that? So in the political context, we're talking about political authorities. The right answer that immediately comes to mind is democracy, elections. Yeah. But, yeah, and absolutely correct. Just bear in mind that a requirement to be elected to an office doesn't make the office holder accountable. It's not enough. What is required is re-election. If there is no process for re-election in reasonable time intervals, then just being elected is not accountable. Yeah. So if you have an office where trying to think if there are examples of that. Yeah, in some states in the US, not many, some judges are elected, but that's it, once. Once they are elected, they are there forever. Well, that doesn't make them accountable. Anyway, what is probably the best mechanism to implement the condition of accountability is precisely the kind of standard democratic procedure whereby the office holder needs to be reelected in reasonable time intervals. That's probably the best mechanism we have for guaranteeing accountability. But democratic processes are not necessarily the best, not always available in many other contexts of practical authorities. Not all practical authorities are political authorities. So perhaps the best, the most familiar, probably the most important context in which that is the case is the employment market. Employers have a great deal of practical authority over their employees. Now, the employees usually don't get to elect who their employer is. They don't get to choose their boss. So how do they have some accountability? But the answer is usually the kind of familiar mechanism of collective bargaining. The right to strike, the right to join a union, the right to be represented, these kind of things. Of course, all this is, all these forms of practical accountability have their limits, right? They're not ideal. They're surely better than nothing. And sometimes they're pretty good. Failing that, failing reasonable mechanisms of practical accountability as a second best, which is sometimes the only option people have, is the right to exit. So if you don't like your employer, there's only that much you can do about it. But at least, normally, you have a right to go home, right to exit. Again, not ideal. Sometimes it's useless. If your right to exit from an employment situation means that you're going to remain unemployed for the rest of your life, that's not good enough. But generally, I think that having your right to exit is the second best to practical accountability. Okay. So this is a general idea, okay? Kind of. I want to answer a couple of objections and to clarify or answer a question or two that arise about this account. And then at the last few minutes, I want to show that the failure of accountability is not only kind of obviously something that applies to autocratic regimes and dubious governments and all that, but it actually has very serious implications in the context of international law and international authorities. They tend to fail accountability. Okay, so some objections, some answers. So first, there is an open question here about scope. at minimum, practical authorities ought to be accountable. The condition of accountability should apply vis-a-vis their subjects, their juridical subjects. Yeah, that's obvious. That's kind of the core of the argument, right? Because the whole point is that having legitimate authority imposes the cost of errors on the subject, and the idea of accountability is to remedy that, to kind of have some balancing requirement as a matter of fairness. Yeah? So the accountability condition clearly applies between the authority and subjects. But it may apply much more broadly than that. Sometimes decisions of practical authorities have practical effects much beyond their juridical subjects. And then the question is, should they be held accountable to those? Now, in the context of domestic law and domestic political realm, the distinction is not practically all that important, because mostly the effects of practical authorities' decisions remain within their juridical subjects. But even in the domestic context, that's not always and not necessarily the case. So a couple of examples. One obvious example, important example, immigration policy. Yeah. When countries that are attractive to immigrants for one reason or another impose various constraints on immigration, obviously those affect people who are not subjects, not only those who are subjects to the jurisdiction of the authority, right? So when US imposes all those restrictions on immigrants from Central and South America, well, it affects people who live in Mexico and Guatemala and etc. So immigration is one counterexample. The other more mundane, less exciting, but important example is strong economies that make various fiscal decisions that affect the rest of the world. So clear example, interest rates. Yeah? When the Bank of England or the US Federal Reserve make changes to their interest rates, that has a worldwide impact. Yeah, well beyond the borders of US or UK or whatever. All right. So what's the answer? Should authorities held to be accountable only to their juridical subjects, or to anyone who is affected by their authoritative decisions, legitimate authoritative decisions? I don't have a knockdown argument about that. I'm not entirely sure how would one argue about it. My intuition, moral intuition, is that authorities should be accountable beyond their juridical subjects. They should be accountable to anyone who is affected by their decisions, if it's a direct effect, right? There has to be some directness, because if you don't require that, then anything anyone does can affect somebody else somehow. Yeah. But if it's a direct effect, then they should be held accountable. And I think the importance of this will be evident, hopefully in a few minutes, when we talk a little bit about international law, right? There, the issue is of great importance. Yeah. Okay. So there is that. Now an objection to my general thesis that the condition of accountability is a necessary condition for legitimacy. People would say, well, we have a very clear, huge counterexample where we think that the practical authority is legitimate And the last thing we want is accountability. What comes to mind? Not far from home, the judiciary in a democratic, reasonable democracy, seeing itself as subject to principles of the rule of law. We want judiciary that is not legally or politically or in any way accountable. Not to the subjects, certainly not to the politicians or the forces who appointed them. We want them to remain unaccountable. Yeah. And we think that when judges are held accountable in one way or another, including, by the way, democratic elections. So I don't know if you know that in some US states, it's at state law level. Judges, like politicians, have campaigns, and they have to be reelected, and they have campaign managers, and they have ads in TV. Horrible. We think that's a huge violation of the rule of law. That's a mockery of a sound judicial system. So is the judiciary a huge counterexample to my thesis? Here's the surprising answer. No. Why not? First, we have to draw a distinction between the judiciary qua office holders, judges, and courts. Judges, qua judges, don't make legal decisions. They make them in a court. So the question is not whether judges are held accountable personally. They shouldn't, mostly, unless they are corrupt. The question was the court that makes legal decisions is practically accountable or not. Yeah? Since the legitimate authority that is being exercised is the authority of the court as a court of law to make decisions, the court is the one who should be accountable. Or the decision of the court, if you want. Are courts accountable for their decisions? Is there practical accountability? So let's look at it. The first requirement of disclosing reasons in most reasonable legal systems I'm familiar with, that's clearly satisfied. Judges, courts need to give their reasons for their legal decisions. Some aspects of the French legal system may violate that requirement. Okay. Not sure that counts as a counterexample. Anyway, by and large, the disclosure requirement is not the problem. The problem is the second component, the practical impact. So are courts practically accountable? Number one, remember that in most cases, there is a right to appeal. So most court decisions are clearly accountable to higher courts. Okay, but at some point you reach the highest level. What then? Well, here there is a huge difference, huge in terms of moral significance, between statutory and constitutional cases, or common law and constitutional case. If we're talking about statutory law or administrative law, then whatever the courts decide is subject to revision by the democratic legislature. I don't know how often it happens here, but in the US, it's not infrequent that the Supreme Court renders a decision, and sometimes very soon thereafter, the United States Congress, believe it or not, annuls it. Says, no, that was wrong. Here's a new law, and the new law annuls, practically speaking, the decision of the Supreme Court. Okay? So courts' decision in ordinary legal matters are accountable to the legislature. and assuming that the legislature is accountable to ordinary people, ordinary subjects of the political authority, then courts are, though indirectly, accountable to all of us. Yeah? Of course, that practically speaking, things are much more complicated. Yeah? But in principle, that's the case. What about constitutional decisions? Well, that depends on many, many details of the constitutional regime. If the Constitution is fairly rigid, if constitutional amendments are difficult to accomplish, like in the US has an extremely rigid constitution. Constitutional amendments are, practically speaking, bordering the impossible. Then it casts a serious doubt, not on my accountability condition, but on the legitimacy of constitutional decisions, of constitutional law. I have written a lot, regardless of this accountability business, against the enthusiasm with constitutional judicial review. I think that constitutional judicial review, especially in regimes which have very rigid constitutions, is extremely problematic. And I have serious doubts about the legitimacy of those. So if I have to choose between constitutional judicial review, condition of accountability, you see where I'm heading, okay? But we can talk about that. That's, this paper is not about constitutional judicial review. It just acknowledges that either that's a serious counterexample or it goes the other way around. Yet another nail in the coffin of judicial review. Okay, let me say just quickly a few words about the implication of this to international authorities. So what are international authorities, for those of you who haven't taken international law yet or ever or something, or will never take? It's not a mandatory subject, I presume. It is? Well, good for you. Okay. What? 2 semesters. Okay. Wow. More than I had. My professor of international law was the president of the University of Tel Aviv. And he wrote like 30 books on international law, all in Hebrew, and all equally boring. And we had to take, I think we had 2 courses in international law. And every course, we were obliged to buy at least 8 of his books. And he designed the tests in such a way that you had to have the book. Otherwise, there was no chance of passing tests. Yeah. I learned a lot of international law, as you can imagine. All right. But I learned some since, luckily. So here's how it works. In what are international authorities? There are various kinds. There are international courts and international organizations. And both are usually created in a similar way. A bunch of countries, a bunch of states reach an agreement, a treaty, to establish these institutions. They define the powers, the normative powers, and the areas of operation of these institutions. They ratify the treaty, and they often, depending on what kind of institution it is, have an allocation of resources funding those institutions. Okay, and that's true about a whole bunch of international courts, mostly regional, but yeah, actually all of them, with very few exceptions. The ICC is not exactly a regional court, but most of them are regional courts applying to, having jurisdiction over a range of issues with respect to a range of countries. signatories to the treaty usually, yeah? Or the various international organizations, some of them with very limited reach, like, again, regional trade organizations, and some of them with huge reach, like the World Bank, the IMF, the World Health Organization, IAEA, etc. Okay, all these acronymed institutions. Now, in terms of accountability, yeah, since these are international organizations created by treaties between states, they are accountable only to the states that created them or that joined the treaty, to the signatory states. Yeah. Very, very few tiny, tiny exceptions. Yeah. There's no direct accountability to any public. There's only direct accountability to the states, and only to those that are signatory to the treaty, okay, that created them. So why do we have serious problems of accountability here? There are at least three serious concerns. I'm not inventing any of this. I mean, this is kind of well recognized in the literature, in international law and international political theory. People, talk about these in different ways, and they come up in different contexts in different ways. But I don't think I'm saying anything new here or anything that would surprise experts in the field. Number one is what I call, and not everybody calls it that way, the problem of accountability distance. In the European Union, it came under the name of the democratic deficit. So the idea is that international institutions make decisions with respect to the fate of tons of people that are very far removed from the authority, far removed not just in geographical distance, but in terms of culture, language, access to information, things like that, right? So the people who make the decisions, or the organizations that make the decisions, make it for peoples that they barely know. And the people barely know them. That's the problem of accountability distance. Yeah. And you can see why in certain contexts it's right to call it the democratic deficit. So in the European Union, they were very concerned about the fact that the EU makes decisions for people in the Union that has direct application legally to them without even knowing their language. Yeah, not to speak culture and etc. And I'm sure you have a very similar problem here with indigenous populations and, things like that. Okay, so that's one issue. The second issue is the problem of agency, principal-agent relations. So international institutions are created by states. The assumption is that the states represent adequately the interests of their people, and therefore they have a right to bind their people to these international agreements, then subject their people to the authority of international institutions. Okay? But then things go wrong when the domestic regimes are corrupt and not representative. So they fail to represent the interests of their people, yet they have the power to bind them to international decisions, international organizations' decisions, which may not be in the interest of those people to be subject to. Okay, so that's an agency problem here. Finally, in my mind, that's maybe the most important aspect. There's a serious concern about inequality of accountability. So most of these large international organizations need funding, sometimes a lot of funding. They get it from a few powerful, rich states. Sure, I don't have to name them. Yeah. And they are directly accountable only to states. Yeah. So, to speak in concrete terms, think about the IMF. There's enormous impact on the economies of many, many countries and many, many millions of people. Some people not far away here to the west. Yeah. Owe a lot of money to the IMF. And then they do crazy things. The World Bank, the same. The World Health Organization. Lots of other institutions. They are funded by the US, the European Union, and Chinese, pretty much. So they're practically accountable only to these rich states. How is that fair? How is that decent accountability? Imagine a democratic system, yeah, where people would get votes according to their wealth. So in democratic elections, not everybody gets one vote. You get one vote for every $10,000 you have in your bank account. There are many things that would be terribly wrong with this system. But one of them would be that it's an outrageously inegalitarian system of accountability, right? Because then the regime will be accountable only to the super rich and a little bit to the less super rich, but rich, and almost zero to everybody else. So we think that's totally unfair. That's not a decent democratic regime, and it's not a decent way of exercising accountability. But what happens in the international domain is not very dissimilar. Yeah? International organizations tend to be accountable only to a handful of rich states. Okay? So I think that we have very serious reasons to be concerned about the legitimacy of international institutions. Doesn't mean that we should abolish them. As I said, legitimacy and soundness come apart. Some of those institutions may be doing very good work, may be doing important stuff, even if they're not quite legitimate. I'm not denying that. Okay? Then there is the issue of the right to exit. In some cases, it seems like an adequate remedy. If a state is unhappy with the subjection to an international institution, in some cases, it can exercise its right to exit. Brexit is the obvious example. Yeah. But Brexit exemplifies why the right to exit has very limited, gives states limited options. Not because it was so expensive for Britain, that's their problem. It's because it's very difficult to imagine that most other states in the European Union could have their Brexit, right? I'm sure that many Greek people thought that we're better off without the EU in many respects, but they had no practical way of exiting the Union because that would mean economic ruin. So a right to exit is not always feasible. And in some cases, it's really not an option. Because in some cases, exercising the right to exit means losing the benefits of international cooperation, which is self-imposed punishment. I mean, think about it this way. international sanctions are precisely that, forcing the state to exit. You're no longer part of us. Go home. Well, that's usually a sanction. That's usually not good news for the state. So employing the right to exit in the international context, even though it's theoretically generally there, practically speaking, is not always an option. But again, I mean, the conclusion is limited. It just says we should have serious concerns about legitimacy of international institutions. Doesn't mean that they're not doing a decent job. Sometimes they are, yeah? And sometimes we may have good reasons to maintain them, even if their legitimacy is a little bit iffy. Okay, should stop.
Well, thank you very much, Andre. All the floor is open for those who want to talk. Rafael, Daniel, Caio, and please take the mic. Okay.
Good morning, everyone.
I just like you to introduce, give your names before.
Hi. Okay, I'm Rafael. I'm Ronaldo's colleague here at the law school. Thank you very much for your talk. I have a question, and much of your thought seems to make accountability dependent on the legitimacy of elected bodies, right? So when you say, for example, that the legitimacy of the judiciary, at least in statutory matters, is there because, as a last resource, Congress can make new law and so forth. And when you mention your criticism of international institutions, a lot of it is dependent on, for example, the inegalitarian characteristic of these institutions. My question is, how does your theory stand in a context in which you can look at the elected body, such as Congress, and identify the same kind of inegalitarianism within that body? So when you mentioned you need your fictional example of if every $10,000 you have, you get a vote, you could, breaking things to the practical aspect, you could say that in many democracies, that is pretty much also a recipe for election, because you have more money to spend in campaigns. Or in case of Brazil, if you're a man or if you're white, you will have, in all things considered, or if your father is a famous politician or owns a TV station, you will have, all things considered, a much easier access to this institution, on which much of, in practical terms, your accountability theory seems to rely on. So how does it stand in contexts in which elected bodies are very unequally gerrymandering? All sorts of imperfections in the agency design of electoral bodies. Thank you.
Thanks, Rafael. My answer is going to disappoint you. Practical accountability, I argue, is a morally necessary condition for the legitimacy of any practical authority. Yeah, maybe parental authority we can bracket a little bit, but otherwise, any practical authority, including in the employment context, yeah, that doesn't satisfy a certain minimal level of practical accountability cannot be legitimate. Okay, that's my point. But the point is, it's a morally necessary condition, not a sufficient one. Right? We would have to tell a much more complex story about what makes employers legitimate authorities, what makes politicians legitimate authorities, the executive, the legislature, judges, you know. And I suspect that we would need to tell very different stories in very different contexts. You know? Now, I have, and it goes, well, maybe I'll get to that. In the context of democratic political authorities, my point here was very limited. I did not intend to give a justification of democracy or show why democracy, or, you know, under what conditions it legitimizes regimes. And all I want to say is that in the political context, when we think about the mechanism by which we implement a certain minimal level of accountability, I don't think we have a better one than, you know, periodical elections. Now, of course, you know, you're right to point out it's more complicated because having periodical elections when the districts are gerrymandered, like in the US, is not good accountability, right? It's not even close. And I think the US, in many cases, especially in congressional elections, especially in the House of Representatives elections, really fails minimal level of accountability. Because the districts are totally gerrymandered. So it's, the elections are not competitive. But in any case, my point is very limited and it only points to a necessary condition. You know?
Thank you.
Just raise your hand so that I can.
Hi, hello. Actually, I have.
Who's speaking?
Me here, Daniel.
Oh, Daniel,
Oh,
yes.
Actually, I have two questions. They're more clarificatory than anything. And the starting point was the distinction between legitimacy on the one side and soundness or justification on the other. And when I saw this distinction the first time in the paper, I thought, oh, right. So I can actually use this to solve my, to kind of put together, let's say, on the footnote, you mentioned Bernard Williams's paper on moralism and realism, legal philosophy. And then you have Raz's thesis of authority. If you have this distinction, you can actually make sense of all of that together. That was my first instinct by reading the paper. But then when you start to discuss legitimacy, you introduce the idea of fairness and accountability come as an offshoot of fairness in the paper. And by the end of your talk today, we actually start to see that legitimacy itself starts to kind of fade away, and what's actually doing the heavy work, doing the heavy lifting in the paper is accountability and fairness. And then I wanted to get a clear grasp if we actually need, for the point you want to make, the notion of legitimacy, especially if we understand legitimacy as a sort of, well, legitimacy is about how someone got to power, and this must be a sort of story that makes sense for the audience, for the subjects. But this is another thing altogether when you talk about this is one thing. Another thing is when you talk about accountability and fairness, because then we are talking in a way about more justification again. So it kind of seems that legitimacy is not doing much of the heavy lifting in the paper when compared to
Lifting what, Daniel? All I want to lift is about legitimacy. That's the topic.
Yeah.
So if you agree that authorities need to be legitimate, it's not enough that they make correct decisions.
Yeah.
And if you agree that the legitimacy of authorities includes the idea of legitimate error,
yeah,
then my point is that the condition of accountability is a necessary condition of legitimacy. That's what the whole paper is about. So I'm not sure where the lifting goes. What am I supposed to lift? I'm trying to reach the conclusion that you don't have legitimacy without accountability. Now, what's supposed to do the heavy lifting, in your words, is the idea of fairness, the idea of given legitimate errors, what is the way to balance the fact that the subjects of an authority, of a legitimate authority, need to bear the cost of its errors. That's what's doing the heavy lifting. But it's lifting towards legitimacy. It's not that I use legitimacy to achieve something else. You kind of reverse the logic of my argument.
Okay, got it. Yeah, I got it. I need to think more about that. But I see the point you're making there. There was. Oh yeah, I see the. Okay, right. So. Yeah.
Now, Caio.
Hi.
Hi, hello. Thank you for the presentation. I'm a PhD candidate here at the University of São Paulo. Professor Ronaldo is my supervisor. I have two questions.
Are you going to disclose your name, or that
sorry,
remains undisclosed?
Okay.
None of our business.
I'm Caio. So, CAIO. My question is on your distinction between legitimacy and soundness as well, and also on where the normal justification thesis is on that divide. You say that every authority is a package of normative powers, and if that package is not morally objectionable, their authority is legitimate. That's what I understood. I understand that having that kind of package of normative powers is equivalent to having power to change people's obligations. And you say if I am correct or not. And changing people's obligation is, I understand, the same as creating obligations to those people, obligations they would not have otherwise if there wasn't a government issuing that kind of directives. But if that is so, my question is, how can legitimacy not be the same as being able to create an obligation to obey? That's my first question. My second question, which is, I think, related to that, is on the place of the normal justification thesis, on that divide. I realize it may be puzzling to think that a dubious president can think about what are our reasons better than ourselves, and create an obligation to be obeyed on that basis. I think, I realize it may be puzzling to describe the legitimacy of that kind of governor in terms of the normal justification thesis. But my question is, wouldn't it be possible for Perez's theory to conclude that we may just not have an obligation to obey that kind of governor? And even wouldn't it be possible for Perez to say that we just don't have an obligation to obey many, maybe most governments, and maybe most governments are not legitimate? I realize that's counterintuitive, but I think that Raz is putting that point. So I would like to hear you a bit more on that as well. Thank you.
Thanks a lot, man. You raise really important issues, which mostly I cannot handle in this paper. It's just too much stuff. And I can, some of it I wrote other places, and some of it probably yet needs to be written, or not necessarily by me. Okay, so let's start with briefly the question: what are normative powers in this context? So you're right. Normative powers is the ability to change other people's obligations, but not only obligations, right? Raz claims at some point, and I used to think that he's right about it, that despite the variety of changes of, normative powers allows you to create new rights, to grant immunities, to, the whole Hoffeldian. They would know who Hoffeld is. What Hoffeld? Okay, sort of. Okay. Anyway, there are lots of kinds of rights and obligations and powers, etc., that authorities can change, And Raz claimed that eventually they all boil down to obligations, to duties. Because to have a right means to have a justification for imposing duties on others, etc. Not everybody agrees. It's not super important in this context. I think, well, I argued for that authorities are not only in the business of imposing obligations, they're also in the business of giving official advice, believe it or not. I have a paper on authoritative advice and non-binding agreements. A huge part of international law is like that. It's called soft law. Yeah? Many treaties and many authoritative resolutions don't impose obligations, legal obligations. So authorities can do lots of things, not just that. But that just comes to show, well, not by itself, but it's in line with the complexity of the relations between the legitimacy of an authority's directive, the soundness of its directives, and the obligation to obey. Three separate things. Yeah. Now, you're right. According to Raz, the question, and I think he's right about that, the question of the moral obligation to obey remains open, even if the authority is legitimate. And actually, Raz at least used to think, long time ago, that there is no general moral obligation to obey the law, even in places where the law is perfectly legitimate. And I share that view. Yeah. So I think that there is no direct link between the legitimacy of an authoritative directive or of authority and obligation to obey. No direct line between soundness and obligation to obey. And the latter more or less according to Raz's analysis. So think about suppose soundness is the normal justification thesis. Okay. So the law requires us to obtain medical prescription for buying certain medicines because it doesn't rely on our ability to figure out what's good for us. Yeah, certain medicines you ought not to buy unless, you have a doctor's prescription. And that's by and large as it should be, right? By and large as it should be. But if you happen to be an expert yourself, even if you don't have a medical degree, you're a biologist, a biochemist, something, and you actually know more about the medicine than anybody else, then the normal justification thesis doesn't apply to you, which means that you don't necessarily have an obligation to comply. Yeah? So there's never the direct link there. And the question of when and under what conditions people have an obligation to do something because the authority, and only because the authority said so, I think remains open regardless of how exactly you understand legitimacy, how exactly you understand soundness. It's meant to answer both your questions. I'm hoping it does.
So just to tell you the list, we have here Danilo, Lucas, Felipe.
Can I just add something to that? Because it may...
Sure.
Non-Razian, totally non-Razian. So one argument I had with Joseph Raz for many years now is the role of consent in legitimizing authorities. According to Raz, consent doesn't play any role. That doesn't make sense to me. I think that in many, many cases, the legitimacy of practical authorities resides in consent or what we call voluntary participation in the relevant practice. So if you ask, why does my dean have legitimate authority vis-a-vis tons of stuff that I do in the university, yeah? It seems to me crazy to think that something like the normal justification gives the answer. No offense to my dean. I have two, so I can claim. The correct answer is that I joined the institution, namely the university where I'm employed, voluntarily, knowing full well in advance that it has a certain authoritative structure, and that by joining, I consent to be subject to the authority of the dean and the provost and et cetera, et cetera. So the authority is based on consent, on voluntary participation. That's by and large the answer to the question, what makes employers legitimate authorities? Okay? Now, to say that just because we have this avenue of consent as the right way of justifying legitimacy of authorities in the university doesn't mean that I have a moral obligation to do everything that the dean tells me to do, not even pro tanto. Yeah? It's obvious to me that the dean's directive is too stupid to be taken seriously, or immoral, or, you know, not really relevant to me, or whatever. I may have no obligation to comply. Sorry, just to complete it.
Hi, Professor Marmor. Thank you so much for your lecture. My name is Danilo. I'm a student from Professor Ronaldo's class. Professor Marmor, in your draft, you say that probably the main practical significance of legitimacy is that officials are not under an obligation to refrain from implementing unsound or mistaken directives, and others would have an obligation not to interfere. So, if we take the judiciary, we should have mechanisms to exercise accountability towards judges' decisions, but not to interfere with the judges' offices. Let's say like that. In Brazil, our Supreme Court justice, they can be impeached by the Senate. And one of the hypotheses of the impeachment is that in English we could translate to some type of unskillfulness. So if the Senate understands that a Supreme Court judge is unskillful in your office, too much and too many and too grave, the Senate can impeach him. So I was wondering if, in your view, this type of a mechanism, this possibility of impeachment of a Supreme Court judge would, in your account, be an illegitimate one.
Thanks. So I think that this would better come under the concerns relating to rule of law, right? So my point was that the way we should think about accountability and being shielded from accountability of the judiciary needs to separate between judges, qua office holders, and the courts, qua decision makers. Now, you know, sometimes the court is just one judge, but it doesn't matter. So I think that the practical authority is the authority of the court. And that's what needs to be accountable. We have very good reasons to shield judges as office holders from accountability, certainly from political accountability, and certainly from accountability to the legislatures or whoever appointed them, and to even more so to the executive. But that's not because of the legitimacy of that's not really concern about the legitimacy of their authority, because their authority is exercised qua court, not qua office holder. It's because of concerns about the rule of law. We want the courts to be independent in making their decisions from populist pressures, from legislatures, certainly from executives, etc. So I think that concerns about the possibility of impeachment of judges, qua office holders, is a concern that comes from rule of law direction.
Thank you.
Lucas?
Thank you, Professor, for your lecture, and thank you, Ronaldo, Daniel, for organizing this. My name is Lucas. I am also a professor of jurisprudence here. Since we can talk about degrees of accountability, one of my questions would be that if impeachment would be a good instrument for the accountability of the Supreme Court judges, or if we can think about fixed terms, fixed mandates for these high courts judges. And another question, I would like to hear some comment if you agree with that discussion about weak models of judicial review that institutionalize an answer, a counter-argument by the legislator to the decisions by the Supreme Court.
What's your question about that?
If you agree with that weaker models of judicial review would
Better than
would be a
stronger.
better
Okay.
answer for accountability.
Okay, thanks. So my answer about impeachment is similar to the answer I gave earlier. I think that the problems about impeachment usually come up in the context of rule of law, right? Including impeachments of office holders other than judges. And they're also very context sensitive. Yeah. What might work in the Brazilian context may not work in the US and vice versa. So I'm not sure what to say beyond that. Okay. In terms of constitutional judicial review, so, this paper is not about that. I have other papers about that. One which I actually gave here in Brazil many years ago, Belo Horizonte. But the bottom line is that I think that the US model is a very bad one in many respects. So I'm not claiming that we should get rid of constitutional judicial review all over, across the board, have none of it. I think that only one or two countries have absolutely no constitutional judicial review. I think it's New Zealand, and until about 20 years ago, Israel. That's fine. Constitutional review is fine. The question is, how is it structured and how much it compromises democratic accountability. The US model compromises democratic accountability to an extreme, to an unnecessary extreme, for a bunch of reasons. One, there is no separation between the Supreme Court and the Constitutional Court. So just 9 justices determine all the law in the United States. So it makes you think, why do we invest enormous resources in democratic elections? Eventually 9 justices, actually 5 of them, can decide what the law is, regardless of any democratic process. 9 justices, or 5 of them, can say, okay, enough with the right of abortion, we're done. Yeah, and now we're stuck with it for the next 50 years. Or they can say, everyone has an individual right to carry arms. Short of a tank, you can buy anything. And if the states regulate that, they violate your constitutional right. And we're stuck with it, and we're stuck with people killing lots of other people because all it takes is to go to Walmart and buy a rifle. So crazy stuff like that, not really needed. And what enables it is partly the enormous power of the Supreme Court, the fact that justices don't even have retirement age. They can stay there forever. The fact that the appointment process is totally random, right? Depends when a justice dies and who's the president at the time. And mostly the fact that the amendment of the US Constitution is extremely, extremely difficult. So every constitutional decision we're stuck with for decades. Yeah. Now, many countries have done much better than that. Canada, for example. Yeah. So there are just better models that can balance in a much better way the conflicting considerations here. And there are conflicting considerations, right?
Okay, Elisa, and let me then tell the rest of the list. We still have to, I think we have time for everybody. But just please try not to be long on your questions. And after Elisa, we have João, you, and Gilberto, and if we have enough time, Eduardo.
Thank you, Professor, again. It's really short. I noticed in your paper, in your lecture, you were talking about how a mistake or an just or unjust decision per se cannot make the authority illegitimate. What calls my attention is the fact that we are talking here about mistakes, or we are talking about evaluation from an observer who claims it's about a mistake or unjust decisions. It seems to me that it's put aside the thing about intention, or in your paper, you talk about how the abuse of the power can be seen as a matter of a form of illegitimate form of authority. But for me, so it seems to me that we have a thing of degree, internal degree, the evaluation of what you say is a mistake or a just or unjust decisions, and what is exactly abuse of power.
So you're right that there has to be a way of drawing a line, distinction between abuse of power and a legitimate decision that is mistaken. Yeah. Now, I think we normally understand abuse of power as something that's done ultra vires, right? So there's a package of normative powers that authorities have. In the legal political context, those powers are usually legally defined. Yeah. And people abuse the power when they just violate the law, when they assume a power they don't have. Yeah. Do we have, and it's not, I don't have an answer. I'm not sure it's easy to give an answer to the question whether we have a notion of abuse of power that's not legalistic, that's not juridical. We should, probably should, but I'm not sure how it would look like. I'm not sure what it is. I haven't thought about it. It's a good question. Okay. The idea of legitimate error, yeah, is not tied to abuse of power. On the contrary, the assumption is it's not a case of abuse of power, as you suggested. It's a case of an exercise of a legitimate authority within the bounds of authority. It's just that on the merits, it's wrong. Now, I know you didn't ask about that, but I'll use the opportunity to expand a little bit. It's the point that I make in the paper, just to give a sense of scope. So one thing one mantra of political liberalism, or generally liberalism in political philosophy, is that we recognize that there is a great scope for reasonable moral disagreements, right? Even profound moral disagreements. So people can reasonably disagree about fundamental moral issues, and in ways that are not easy to reconcile. right? I mean, you can't have it both ways. And that's fine, and we should have a legal system that works with that and allows people to have these reasonable disagreements settled. But what the implication of it is that many decisions by legal political authorities are going to be seen by part of the population, not insignificant part of the population, as profoundly immoral or profoundly unjust, whereas by the other part as totally okay and just and moral. Yeah. So we're always going to have cases, continuously going to have cases where, from the point of view of reasonable people within the jurisdiction, the decisions of the authority are unjust or immoral. Yeah. So the idea of legitimate error is actually has very significant reality to it. Yeah, and it's bound to have it if you believe in reasonable pluralism. Yeah, but you're right that it should be distinct from abuse of power.
Thank you.
So
I'll try to be
go
short.
ahead.
Okay. Thank you, Professor, for your lecture. My name is João. My question is about your concept, your definition about accountability, since I think it's very important in your claim, since it's it's necessary for the characterization of the legitimacy. So my question is especially related when we have to the situations we have a hierarchical system of recourse, which you can see in judiciary, but also in administrative issues, like you said about your requested to the dean, until it gets to the top, which is the president of university. So at first place, I assume your definition of accountability was related to the disclosure, obligation of disclosure, which is we can effectively see in this, not in the top, but in the lower instances of this system. But when we reach the top, you have this issue of disclosure, because we cannot, there is no instrument to make the top authority to disclosure. So for me, it seems that the criteria changes to disclosure to possibility of reverse the decision. And I wonder which is the criteria that defines more precisely the accountability in your view. I'd like to hear you about that. And if you have this change of criteria, if there is, we have always a problem of legitimacy of the top authority in this hierarchical system of recourse. Thank you very much.
Thanks. The two components of accountability, practical accountability, are not two alternate definitions or features of accountability. They are two separate, independent requirements, and you violate accountability either by not disclosing the reasons or disclosing the reasons, but you still have nothing to do about it. Yeah. So each one is a necessary part of the package. The package just has two ingredients. One, authorities, generally speaking, can never refuse or fail to disclose the reason. And by disclose, I mean truthfully disclose. I mean, lying is not disclosure. Yeah. But truthfully disclosing the reasons for their decisions. So that's one requirement. The other requirement, okay, that's not enough. Even if you disclose the reasons, subjects of the authority should have some availability of some recourse to remedial measures, right? Something to do about it. Yeah. And what to do about it varies enormously according to circumstances, but some minimal recourse. And these are, together, they make up what I call accountability. Okay?
All right. So my name is Guilherme Almeida. I'm a professor at a different university here in São Paulo. And I have like two very quick questions. So the first one is a little bit a methodological question. So throughout your draft and your talk, which were both very interesting, thank you for that. There are a few appeals to intuition.
There is a connection between them.
Yeah, a little bit of a connection, perhaps a tenuous one, but but anyway, there are like a few appeals to ordinary intuitions, right? Which I think aim to establish that there are two different concepts in play when we're talking about authority, right? So we have a legitimate authority and we have sound authority. And your claim is that these two concepts are both extensionally and intentionally different, right? So that you can have like a moral obligation to comply with a directive from an illegitimate authority and vice versa. So my question is, to what extent are you committed like to those appeals to intuition, right? To what extent is your argument contingent on like people actually having the linguistic intuitions that you are assuming throughout the paper? In other words, like if future experiments would show that ordinary English speakers don't draw the distinction in the same way that you do, in the sense that they don't think it is possible to to have an obligation to comply with the demands of an illegitimate authority and vice versa, would that threaten your commitment to this distinction or not? And that's not to say that I'm skeptical about it. I think that if the experiments were to be run, they would come out the way that is predicted by your theory. It's just like we often see appeals to intuition in general jurisprudence, and it's quite hard to know what's the epistemic status, what's the epistemic role that they're playing. And my second, even briefer question is just like, well, isn't some of what Ross is saying with regards to the normal justification thesis also relevant to your sense of legitimacy? Of legitimate authority? For instance, like in a democratic setting, is it possible for an authority to be legitimate in your sense if it flaunts the dependence thesis? In other words, I think it would be very natural for people to say that an authority that like reach power for the appropriate means, but nonetheless uses those powers to benefit themselves instead of benefiting the governed. I think that they would say, well, so they're making their directives not with aims that advance the reasons that I would have independent of any authority, but on completely different reasons that are self-serving to them, not helpful to me. So those are the questions. Thank you very much.
The methodological question is a very complicated one, and there's you seem to be it seemed implied by your question that you're much more sympathetic to two views that I am more skeptical about. One is that we're dealing with concepts here. I don't think we're dealing with concepts. We're dealing with moral ideas. Now, you rightly ask how much the articulation of these ideas depends on contingencies of the languages we speak. And my answer is, I hope none of it. Or, well, it's difficult to think without language, right? We wouldn't be humans if we didn't have language. But I hope none of it is too sensitive to that. So if you tell me that there is a language, spoken language, natural language, in which there is no distinction between the word sound and the word legitimate, they use the same word. Might be the case in Hebrew, actually. I haven't thought about it carefully. Because in Hebrew, to say legitimate, they just say legitimate in English. So maybe there isn't a word for that. Anyway, suppose there is a language in which there's no distinction. Then I would have terribly failed in my moral reasoning if I could not clarify my distinction to speakers of that language. You'd say, okay, we call it by the same name, but look, there are different phenomena here, right? We think that what makes Bolsonaro a legitimate president doesn't have much to do with the normal justification thesis, and almost everything to do that he was elected by a reasonably fair democratic process, and we care about democracy, etc., etc. Yeah, I can explain that, even if you think that there is no verbal distinction. The other, well, maybe it renders the second assumption not so important now. I'm extremely dubious about experimental philosophy. So if you had in mind something, let's do experiments, see how people understand legitimacy. It's okay. All the power to you. Just please move to the psychology department. Okay.
No, thank you, but
Yeah. Anyway, your second question, remind me.
so the question was perhaps a little bit contingent on the first one, because
No,
the
no,
idea-
no. You had a point there.
All right.
I
so,
just.
so the idea is that perhaps there is some leftover of the Razian
Ah,
definition.
yes. The question about the dependencies.
Yeah, exactly.
You're right. Well, the dependency, let me explain what the dependencies are. Raz thinks there are three conditions for the legitimacy of authorities. One, the main one is what he calls the normal justification thesis that we're talking about. And the other one is that authorities have to base their decisions on reasons that apply to their subjects anyway. Yeah. So if I'm an authority, I need to base my decisions on reasons that apply to my subjects, not reasons that apply to me. Yeah. Or to my cousin. Yeah. It's not the same. So there are two ways to look at it. One, which I'm sure Raz thought, is that the dependence thesis is entailed by the normal justification thesis, right? Because if what justifies the legitimacy of an authority is the fact that you're better off complying with the directives of the authority than trying to figure out the reasons by themselves, that only works if the authority is thinking of what reasons apply to you. So it's entailed by the normal justification thesis. But you don't have to look at it that way. You can say, regardless of the normal justification thesis, there is some truth, just morally speaking, to the dependence thesis. Yeah, that authorities should base their decisions only on reasons that apply to the subject. Again, my accountability condition, as I said earlier, is only a necessary condition. Lots of other things can come in, and maybe something like the dependence thesis has to come in too. And over the years, occasionally I thought about what do I think about the dependence thesis? Does it really apply across the board? And I'm not sure. I think by and large, yes. Who would disagree with that? But is that a necessary condition? I'm not sure. Yeah. But anyway, it doesn't have to be derived from the normal justification thesis.
Yeah, thank you very much.
Well, I think we still have time for two quick questions. Gilberto and Eduardo. But after that, we have to finish.
Yeah, it's a very brief one. Thank you, Professor, for your talk. I'd like to ask you, please, if it is possible for us to take a claim to legitimacy in the sense of your talk, in the sense of your paper, as part of the very role of legal institutions. When we speak of legal institutions, we speak of a claim to legitimacy in the sense, and if so, illegitimate legal systems in this sense are then defective instances of law? Those are my two questions, and the second one is, of course, contingent on the first one. Thank you very much indeed.
So the answer to the first is relatively easy. As I said, authorities are always packages of normative powers, claims and exercises of normative powers. If you claim to have a normative power, that claim should be morally justified. Yeah. So if it's morally unjustified, then you're not legitimate. So there is a very direct connection. So my answer to your first question, yes. I don't see other way of thinking about legitimacy, but as you know, justification of the normative powers you claim to have. Now, there are all sorts of ways in which those claims or the exercises of those claims can go wrong. I don't think it's just one way in which can go wrong. It also ties to the question of the abuse of power. Yeah. But abuse of power is, again, it's just one way in which all sorts of ways, and not all the ways in which it can kind of make the authority totally. So again, there are legitimate errors, and sometimes legitimate errors, unavoidable errors, etc., etc. So I wouldn't jump to the conclusion that it necessarily makes the authority defective in any way.
Thank you, Professor, for your lecture. My question is, it's a simple. I think it's a simple one.
Name?
My name is Eduardo. I'm a student here in the university. If I'm not mistaken, your point about accountability essentially hinges on the concept of transparency, in the sense of that for an authority to be accountable, the reasons need to be open to the public scrutiny. I think it's obvious. But I might say that we have to consider some cases where authorities have to make political decisions that can't be fully disclosed. Not the reasons itself, but the decisions itself. For example, the hostage release negotiations in the recent Hamas-Israel conflict. If these negotiations had been unsuccessful, it might have been important to keep them secret, even if there were calls for disclosing their existence. The question is, are there times when authorities, to stay accountable to the public, should or must choose not to disclose certain actions or decisions? If those cases, is there some kind of invincible deficit of legitimacy, even if they are totally moral justified? I think the point is that relation between transparency and accountability, and the need of secrecy sometimes. Thank you. Thank you very much indeed.
So I think you picked a bad example for your point. No, because it's about the structure of things. What authorities need to disclose is the reasons for their authoritative decisions, not the reasons for everything they do. Yeah. So in this case, the Israeli-Hamas negotiations, the authoritative decision is not how the negotiations were conducted, but what's the result of it? Yeah. The release of a certain number of detainees, and the decision to have a ceasefire under certain conditions. That's the authoritative decision. And the reasons for that are transparent for everyone to see. I mean, they're not, they have been disclosed. And that's fine. That complies with what I would think of as a condition of disclosure. I'm not denying that there might be cases of national security. I know whenever somebody flags national security to me, I allow myself to be very dubious. Okay? But there might be cases of national security where you have an authoritative decisions and it's just too dangerous to disclose the reasons. Maybe. Okay. So there are exceptions, but I'm sure they are much fewer than politicians claim that they are. Yeah.
Okay, well, unfortunately, you have to end this lecture. Thank you again, Andre. Just like to say that on next Tuesday at 10, from 10 to 12, we have the final lecture on rationalizing practices, metaphysical versus hermeneutical theories of law. So you are all invited. And I'd also like to say that this lecture special is the fourth meeting of the permanent workshop on legal theory, political and moral philosophy. It's a kind of long name, but it's and we previously had the opportunity to have some discussions with Kristen Rundle from Melbourne University, Claudio Michelon from Edinburgh University, and now we have the pleasure to have you here. So for us, it's really good. And finally, I'd like to thank again all the help and support that was given by Iago Mina, João Vitor, and Daniel Murata in organizing this meeting. So once again, thank you all, and thank you especially you, Andre.
Thank you for inviting.